Good afternoon, everyone. As people are still filling in to take their seats, I'm going to say a few remarks very briefly before we get to our first panel. Welcome to the annual FBA Class Action Symposium. This is not 2025. For those of you who signed up in November of 2025, thank you very much for your patience and welcome to our first major program of the year, which is always one of our fantastic programs, the Class Action Symposium. Before I turn this over to our first panel, I want to thank you all for being here and supporting the Federal Bar Association. The FBA is an organization dedicated to offering all federal practitioners, judges, attorneys, law students, a forum for career development, networking, education, engagement with the federal bench, and most importantly, from my standpoint, collaborating to ensure and protect an independent judiciary that is accessible to all. My name is Chris Stecker. I am privileged to be this year's president of the Northern District of California chapter of the FBA. And I'm very excited to continue the hard work and legacy of so many FBA members in this room who have dedicated their legal careers to the goals that I mentioned a few moments ago. And we do that in a few ways. And the first is by encouraging membership. For those of you who are not yet chapter members, I would encourage you to visit one of the QR codes that you'll see in the hallway and sign up to be an FBA member, where you will get access to programs like this afternoon's and so many other programs that the FBA puts on every year from an educational, networking, and career development standpoint. Along with that membership, I would encourage you to go back to your law firms and inquire about becoming annual sponsors. And I don't want to pass up an opportunity to thank those firms who are this year's sponsors. You will see their names on the banner outside this courtroom. And for those annual sponsors, they have privileges and opportunities to participate in events like this and other programs throughout the year. And I thank each one of those sponsors. Please do take a look at the flyers and banners outside. And one of the best ways that we do, or best things that we do to bridge the judiciary between the judges and students and attorneys is through the programming, like today. And some of the program that I'm just going to describe that's on the immediate horizon, including next week on February 3rd, we're having our annual mixer at the Coblins Law Firm. I'd encourage any of you to sign up and become a member, and then bring a friend to that mixer and find out more about what the FBA offers. Our next major event after today is what we've called Views from the Bench on February 24th. That afternoon, you will hear from district judges in San Francisco about what works in their courtrooms and what does not work in their courtrooms. It's a must attend for all those who practice in federal court. On March 5th, we have a program that's entitled The State of Play in Generative AI Cases. So for all of those here who are interested in artificial intelligence and its overlap with legal cases, that's on March 5th. Please consider registering and attending that really, really exciting event. And then the last event I'll talk to you about is something that's always really fun for me. It's our Judges Dinner on March 11th. That is open only to FBA members, and it is a limited attendance event at Palio. People have already started registering for it, and those tickets sell out. So please do consider registering early for that event, and again, encourage others to become members. Now today, we are blessed to have 4 wonderful, wonderful panels. And each one of the panels is going to introduce their topics and the presenters. But I do want to thank the moderators, Judges Corley, Lynn, Lapson, Freeman, and Chen, for devoting their time and effort and experience and expertise in putting their panels together. We're very grateful for that. I want to thank the practitioners who are spending time on each of these panels. You are about to hear from the best of the best. You're about to hear from the true experts in their fields, not just about esoteric issues, but on how they are handling cases and different issues that come up on their cases on a day-to-day basis. We are truly lucky to have them here and provide us with their experience and knowledge. I want to thank our sponsors for today's event, Kecker, Van Nest, and Peters, a law firm in the city that has been tremendously supportive of the FBA over many, many years. Thank you for sponsoring today's event, as well as FedArb, an ADR service provider which provides services across the country. And we are lucky to have a member of FedArb, Judge Walker, who is going to be presenting on one of the panels later this afternoon. Thank you both to Kecker Van Nest and FedArb. And finally, before I turn this over to our first esteemed panel, I want to thank Yaman Salahi and Anjali Srinivasan, who have coordinated today's class action symposium. As I mentioned, this was supposed to happen in November, at a time when both Yaman, who is in the first row over here, and Anjali were going to be participating. Anjali could not be with us today because she is about to give birth to a child, and I know that she wanted to be here otherwise. But
she did give birth?
Yes. She did give birth. So congratulations to her. But thank you, Yaman, and please do pass along our thanks to Anjali for the wonderful work that you're doing. And with that, I will turn this over to our first moderator, Judge Corley.
Hi, welcome everyone. I'm Jacqueline Scott Corley. I'm a district court judge here in San Francisco. I've been a district court judge for almost 4 years, and before that served 11 plus years as a magistrate judge. So for almost 16 years now, I've been adjudicating class actions here in the Northern District of California. And I'll allow my panelists to introduce themselves, and we're going to be talking about communications, attorney communications with absent class members. So pretty narrow, but pretty important topic.
Hi, everyone. My name is Sophia Gold. I am a partner at my own small firm called Khalil Gold. We practice exclusively consumer class actions across the country. And I have had the pleasure of being up against Sarah, who will introduce herself in a second, many times before.
Thanks, Sophia. Sarah Davis with Oric here in the city. I'm a counsel, and I am a class action specialist in the complex litigation and dispute resolution department, mostly specializing in class action defense with a specialty in defending banks, fintechs, and technology companies.
So we're going to have a colloquy up here, and we encourage you, if you have questions, to go ahead and raise your hand and ask them as opposed to holding them until the end. So let's begin, Sarah and Sophia. Are there any rules of professional conduct that govern attorney communications with absent class members?
Is there a clicker for that?
I do have a clicker.
Right here. Okay.
Yeah. Let's start with the rules. So there are no specific for class or putative class member communications. So the rules that we look to are the rules for communications with unrepresented parties and represented parties. We do have the model rule for unrepresented persons, which we put up there, as that would apply to the putative class members. The California rule for professional conduct is up there too, but we'll cut to the chase with the TLDR. It's for putative class members, it's really don't be misleading, be clear about who you're representing. If there's any misconceptions about who you are, if you have a representing them, you have to clear it up. And no legal advice if your interests may diverge.
What do you mean by that, if your interests may diverge?
Yeah, that's a great question. So I think your interests have to be perfectly aligned. So for example, I think if you are talking to an employee who is part of a putative class, you wouldn't want to give them advice about their claims. You would want to be very clear that, you know, here's here's our position. We're investigating our what it is, but we are not here, no adverse consequences, but they wouldn't be like, do I have a legal claim? You can't say no. You can't say yes either, probably. You should probably just advise for counsel at that point.
Now, is there a different rule that governs post-certification?
So glad you asked. There is. See how my clicking skills are. Do you want to do this one or you want me to keep going, Sophia?
You got it.
All right. So there is a represented person. This applies for post-certification. And this is a much stricter rule, which makes sense. At that point, you are dealing with folks who are represented by counsel. And so in that case, you really can't communicate with them on the subject of the lawsuit without getting clearance from opposing counsel or their counsel. And we have the site for the California rules for those practicing here. TLDR is pretty short and sweet for this one.
I have the ADA model 8.4 because I feel like as a plaintiff's lawyer, I am frequently referencing that rule. And that rule says it's professional misconduct for a lawyer to violate or assist or induce another to violate one of these rules. And it comes up in this context when we're talking about in-house counsel potentially disseminating a settlement offer or a release or potentially an arbitration agreement, and whether there has been any sort of conversation that occurred between in-house counsel and outside counsel. So I find myself referencing that rule frequently in this context to say, hey, it's not enough that you weren't the one who drafted this settlement agreement. If you knew about this settlement agreement when you were trying to pick off my class representative, or if you reviewed this settlement agreement when you were trying to pick off my client, that could be a problem for you under the rules.
So those are great. Those rules are professional responsibility, but as a federal judge, I don't really enforce those. Are there any rules, federal rules of civil procedure that would apply that I might look to?
Yes, there is. So there's Rule 23D. So obviously this comes from the Federal Rules of Civil Procedure. It is not an ethics rule, but this rule has a lot of teeth. It has a lot of bite. And under Rule 23D, if you were to read the rule itself, you might not think so. It says something like the court has the power to impose conditions on the representative parties or on interveners and to deal with similar procedural matters. But what we know from Gulf Oil is that the Supreme Court has interpreted this rule very broadly to say that not only does the district court have the authority and the discretion to potentially issue an order to protect class members in a putative class action, but actually it has the duty to do so, to exercise control over class action by regulating or restricting a party or counsel's communications to protect the fairness of the proceedings. And I would say that this rule comes up perhaps more frequently than the ethics rules in my practice. I'm not sure if that's similar to your experience on the bench or your experience on the defense side, but I would say we're relatively frequently in seeing 23D or the possibility of moving for some sort of relief under 23D. And luckily, I am not super often accusing my opposing counsels of ethics violations.
Yes, I would say that, on our perspective, we would say it was a high bar to intervene in that circumstance, to in affect or limit our communications with absent class members. But of course, we're always mindful of our duty not to be misleading. So
we're talking, just make it clear, pre-certification here. And Gulf Oil says that both plaintiffs' counsel and defendants' counsel have the right to speak to the putative class members. But when we see the rule come, it's when primarily defendants counsel have what is deemed misleading communications with those absent class members. They're not yet represented by plaintiff's counsel. But under Rule 23D, the Supreme Court has said that the court has the power to correct any misleading communications that occurred.
And you do need, I think this is what Sarah was referencing, you need some sort of evidence of actual misconduct in order to get that order. So I think, Judge Corley had an experience recently that we're going to talk about in a case where this came up. I've had it come up in some of my cases where I've received the actual misleading communication, or I was made aware of the misleading communication, and I was made aware of how class members were interpreting that potential communication. And you really need that evidence. You need some sort of compelling evidence to present before the court to get that order to prevent it from happening. You can't probably go in the hypothetical and say, well, this happening in the future. This is when a defendant has actually done something, or a plaintiff's lawyer, I suppose. That's problematic.
So, Sarah, when might defendants counsel need to communicate with putative class members?
I'm so glad you asked. So there's lots of circumstances. I think, with defendants, sometimes it comes with just updating your terms of service, your terms of employment, which could include adding arbitration agreements. It's to investigate allegations. I think, normally when my clients get sued, they want to know, okay, like, did we do anything wrong here? And so they want to go and figure it out, and the on-class action, that's even more important because obviously the liability is, extrapolated to being much larger. So to do that, they have to investigate, right? And the people they have to investigate with are the absent class members frequently. Which is kind of the other tale of to defeat class certification or to defend class certification. This is one maybe trying to persuade, which I think, gets you on the edge of the rules, but, kind of give perspective on the position and dissuading from joining. I think that, like I said, puts you probably on the edge of the rules. This comes up when people try to settle individual claims or pick off potential class members. I think Sophia will probably have something to say about that. But I mean, I think when you do that, you can potentially do that. One of the cases we'll talk about today, if you do it in a non-misleading manner, right? Some claims shouldn't go to trial, shouldn't go through class certification if you can have an early resolution that satisfies both plaintiff and defendant.
And Sophia, how about before you're appointed or the class is certified, what communications might a plaintiff counsel have with absent class members?
I have to say it's fairly rare in my practice, and I'm not sure if other plaintiffs' lawyers in the room who I see would agree with that, but it's fairly rare for us to be affirmatively going out and speaking with absent class members. Certainly we have the instance where absent class members hear about a lawsuit through whatever means and they contact us and they would like to know more information about the lawsuit, which I view as a different matter. But it is not the case that we're in the position that a defendant is, where we're trying to affirmatively reach out to absent class members to speak with them about potential claims. It hypothetically could come up to support class certification or potentially to identify a replacement class representative. But for the most part, I would say we're in the position of guarding against it from happening from the defendant's perspective, rather than engaging in a lot of it ourselves.
I would say I've seen it when I've, come in on the employment side as a class action specialist, where they're more interested in getting some more kind of a battle of the declarations, if you will. So then we usually go through like the Bel Air privacy process and kind of limit that process. So something to keep in mind if you are trying to reach out for the employment context.
So now we're going to talk about a particular communication, and you're probably all aware of this. I would say my law motion calendar has, on average, one motion to compel arbitration a week. This is what the federal courts are doing these days. We're spending, Judge Martinez Hogan saying, yes, a lot of their time adjudicating motions to compel arbitration. But what happens if the lawsuit gets filed and there is no arbitration agreement? Is then typically maybe in an employment context, is the employer permitted to impose an arbitration agreement at that time after the lawsuit is filed, and it can be pre or pre-certification even? What are some ethical considerations or cases we might look to about that?
Great question, Judge Corley. So enforceability is, from the defense perspective, is going to be the client's primary concern. How arbitration clauses are added and the content of those communications can also raise ethical concerns for us lawyers. Most the 6th and the 11th Circuit have recognized this explicitly. So we'll kind of briefly go over a couple of those cases. The first one is Russell v. Citigroup. It had a pretty strange fact pattern. Basically, a former employee sued and he had an arbitration agreement in place that did not cover class actions. So they initially did not move to compel because it wasn't covered. And then he went and actually sought reemployment at another division of the company and got rehired. And at that time, there was an arbitration provision. By that time, there was an arbitration in place that covered class actions. So they went to try to enforce it. And so, interestingly, they raised whether that was an ethical concern, because at this time, this was a represented party by counsel, and had been given an agreement that did not disclose or reference, understandably, since it was just a general employment agreement and not specific as to his employment. That they were communicating kind of ex parte, if you will. I'm sure there's a better word for that. And then that raised ethical concerns. So they just raised the concerns in Russell because they determined that both parties didn't intend this employment arbitration agreement to cover the situation. That really the manager who was giving the agreement, didn't intend to bind him to this arbitration agreement. He was unaware of the pending litigation. And even though the plaintiff in this case had signed the agreement, he had manifested that he was opting out in other ways besides the traditional opt-out process laid into the agreement. And then they decided the case on completely other grounds, saying that the arbitration agreement was prospective, but it raised the concern.
And to take a step back from a 1,000-foot view here, we're focusing on these two circuit court opinions that are outside of the context of California law. And in many parts of the country, it is much more unsettled whether you can add an arbitration provision in the middle of a pending lawsuit and have that apply to the pending lawsuit. So that's why courts are reaching these opinions in the manner that they did. In California, I think it's actually a little bit more clear cut. I'm not sure if Sarah would agree with me on this, but generally the reasoning that we see under California law would be the implied covenant of good faith and fair dealing prevents you from modifying whatever terms and conditions that you have with a party in the middle of a pending lawsuit and apply that retroactively to a case that's already pending in court. That's not quite an ethics opinion, but it's just something that prevents this situation from even occurring as frequently, maybe.
Yeah, I mean, I would not think that the rule is as clear probably as Sophia does. But I think especially, when people are updating terms of service, and if you provide an opt-out, there's different processes I think you can put in place, because there's definitely companies that are kind of always in the process of litigation. And so the idea that, you cannot add it and enforce it to something that maybe you get the proper, I think, disclosures, et cetera. But I do think that a seasoned, which, you allow arbitration to gain some legs before trying to enforce it is always one that you'll have a stronger argument for, I guess I'll say.
But another case where this came up is Dasher versus RBC Bank, which is out of the 11th Circuit. And that was in one of the cases in an MDL having to do with overdraft fees. And in that case, the bank did try to add a new arbitration provision after the case had already been filed and tried to get it to apply to the pending lawsuit. And the court was obviously very concerned about the potential ethics issues that were associated with that. And it cited the model rules and the state analogs there about how troubling it was that there may have been these communications between counsel and those who were trying to be represented as part of the putative class. And the court said something like, we don't intend to write an ethics opinion here, but we do find it important in terms of ruling that there was no assent and no agreement to arbitrate between the class and the bank there.
All right.
Do you want to discuss Cox?
Sure. I would like to. I think notably from a defense counsel's perspective that neither Dasher nor Russell explicitly bar communications with absent class members or address how the addition of arbitration agreements affect class certification. This was explicitly recognized also in the 10th Circuit, I guess not also, but separately in the 10th Circuit, but in Cox Enterprise. And they upheld the arbitration agreement and rejected the application of Russell, finding that prospective plaintiffs, that's unnamed class members, were not parties to the litigation. So I think in this case, they found the communication was not misleading. It was straightforward and provided an opt-out process. And so they were, distinguished Russell on those grounds.
So in sum, what are the risks you think that are associated with attempting to add arbitration clauses during pending litigation?
I mean, for my clients, the biggest risk is always the non-enforcement and kind of the costs of that process of moving to compel, getting it unenforced. That's the thing I think that they find the most concerning. So they can sever the agreement, then you can be subject more to class liability because usually your arbitration agreements have class action waivers. What about you, Sophia?
Well, I'm relieved to say that most defendants do not try it in my cases. And in fact, I've had several defense counsel tell me, we're adding an arbitration provision, but I just want you to know we're going to use it in future cases, but it's not going to affect your currently pending class action. And I think that is a much more palatable way of doing things. It certainly avoids the fight.
Another risk that I might add is just how the judge is going to perceive the defendant's case. I mean, if a defendant attempts to add an arbitration agreement after the case has been filed, what's the natural reaction? Well, one, you don't want me to decide the case, but why not? Because you don't have a very good case, right? And you should not underestimate the power of that psychological environment that goes on in litigation, right? Judges, we struggle and work hard to get the right answer for sure. But we're human and there's always these environmental things going on. And I don't think you ever want to convey to the court a lack of confidence in your case. And trying to, after the fact, insert an arbitration agreement to me just conveys a lack of confidence in your case, because you could just, okay, now you realize you're outside counsel and you realize your client doesn't have one. And so you say, okay, let's get one going forward. I think that's probably the thing to do. Interestingly enough, I think maybe the reason I was invited to this panel is I have this case in which that's exactly what happened. The case was filed, and I think maybe 22 months or something into the case. And after class certification was fully briefed, this was early December of 2023 or two, I can't remember. After it was briefed, scheduled to be heard in January, on December 19th, it was an employment case. The defendant ruled out to all its employees mandatory arbitration provision and said, if you continue working here past December 31st, you have agreed to it. For those employees who were members of the putative class, remember, it had been briefed but not decided, they sent a separate email saying, if you sign this and send it to us by January 9th, then it won't apply to this pending litigation. And by the way, notice hadn't gone out yet. So this was the first time almost all these employees had ever even heard of this litigation. So they didn't even know what you were talking about. Defendant's counsel did bring this to plaintiff's counsel's attention after it went out. And then plaintiff's counsel came running to me saying, do something. And we had a hearing, and defendant said, well, we don't even know if it wasn't part of the briefing, right, for class certification anyway. So I did do, pursuant to Rule 23D, an order that said any future communications that defendants have with the putative class regarding this litigation must be shared first with plaintiff's counsel. So I just did that. Went forward with the class certification hearing, and I granted class certification. No, they didn't bring up the arbitration provision, and so I frankly assumed, yeah, you wouldn't put this in the middle of litigation, that they had just dropped it. But then about 6 months later, they actually moved to compel arbitration for those employees who had not get out of the arbitration agreement. All right, so plaintiffs bring a motion. So defendant then brings a motion to compel, plaintiffs oppose, and I denied the motion to compel arbitration. And as you know, after Coinbase, case automatically went up to the Ninth Circuit. I kid you not, the Ninth Circuit issued their decision this morning. This morning, yes. I'm walking to work, and I look at my phone, and I get the email from the Ninth Circuit with Avery, and Judge Coe wrote it. It's a published opinion. I did not even tell her it was coming in. And that is just bizarre. In any event, I was affirmed. So this is an important decision, but let's do a show and tell, and you tell me if you agree with the Ninth Circuit, because it's no longer not me, it's the Ninth Circuit now. So the communication, the email that they sent out, no prior notice, said, when talking about this arbitration provision, in our experience, litigation in court, particularly class and collective actions, are wasteful, inefficient means for resolving disputes, and tend to enrich only attorneys rather than the individuals who may have legitimate claims. Does anyone see an issue with that? Like, no, this is true. It's in this published opinion. Again, they said that again. Again, like 3 or 4 times in these emails, they say, which generally tends to enrich attorneys, not individual class members.
And I have to say, I've seen that a lot as a plaintiff's lawyer, about those lines about what a class action is and how bad class actions are, and how those are so terrible. Unfortunately, I would say this is not a one-off. This is something that has been circulated in some trade group somewhere that people are taking this language from, because it's been used.
And it said a class claim required, this is what remember the defendant to the putative class members, a class claim requires the company to ignore individual employee issues and concerns. Additionally, attorneys, not employees, are often the biggest winners in class actions, often charging exorbitant fees to both the class and the employer involved, reducing the money actually received by class members. It did, at the very end of it, say you are, of course, free to consult your attorney, but it didn't have, the plaintiff's attorneys didn't have any links to the litigation or really say very much about it. The other thing was this email rolled out on December 19th, and they had to do something by December 31st. And so I found all those words were misleading, plus you can consult, who's going to consult it over the holidays, right? Or really even read it. So applying 23D, which gives the trial court the power to sort of police the communication and make sure the class action process is fair, I declined to compel arbitration, saying that those were misleading communications. And in fact, it turned Rule 23 on its head. For those employees, made it an opt-in rather than an opt-out. Because in order to be part of the class, they had to affirmatively sign something to get out of that arbitration agreement. On appeal, the defendants argued that the FAA, and we all are the policy of enforcing arbitration agreements, that's sort of trumped Rule 23D, and 23D did not give the court the power to invalidate that arbitration agreement. And by the way, district courts in the circuit had been invalidating agreements like releases, right? The one-offs where they'll get a release from someone. They had been doing that, but the Ninth Circuit had not weighed in on that. And now, as of this morning, they said in binding precedent, at least at the moment, that Rule 23 gives that power.
And they also invalidated the delegation provision, which was important as well, because they tried to include, that the arbitrator should decide this, and the Ninth Circuit said no.
So Sarah, I'm wondering what, is there a question? Yes. You know what, honestly, I don't remember. Truly, I don't remember, but
and I think it was, internal counsel who said it.
So Sarah, then, what takeaways do you have as to, we do know that defense counsel can have communications with a putative class before certification. What maybe could that defendant have done in order to have an arbitration agreement that would apply to the class members?
Yeah, great question. I think if they would have sent out a neutral arbitration provision, preferably not in a DocuSign email, but one that was clear, said they were updating their terms of service, said they were explicitly adding an arbitration provision, said what it would cover, and gave a reasonable opt-out period. I think in order for it to be enforced as the pending class action, I think they probably would have also arguably needed to include plaintiff counsel's contact information. I think they included the complaint, maybe, or a link to the complaint, but they would have to include, I think, contact information and disclose that, you could reach out to them, which they may or may not have wanted to do in that circumstance.
Sophia, you seem to think there's actually nothing they could do.
I would certainly take that position. I mean, there's something innately troublesome to me that when you file a case in court, that the defendant can change the rules of the game midway through and oust putative class members from participating in that class action once the litigation has already begun. And I think there is some strong California law supporting that. The Haleg versus Neiman Marcus case, I actually just got a good order on that in the Ash versus Axis case, which was in the Southern District of California. It was a similar thing where a defendant tried to add it afterwards, and the court invalidated that addition of arbitration after it had already begun. So I think even if you send the best notice in the world, even if you include plaintiff's counsel, even if you name the case, describe exactly what the case is about, I think it's problematic if you're trying to do that and apply it to currently pending litigation.
I, of course, disagree, but, I think it is all about, you say changing the rules, but I think from a defense perspective and often from a defendant perspective, the rules, as long as you're giving the individuals the information and they have the opportunity, I think the opt-out opportunity is very important for trying to enforce retrospectively. And making sure that you're not taking away any kind of, like, as you know, if you're taking away the main benefit, then the opt-out can be considered somewhat illusory.
Going forward, because I would argue that you are turning an opt-out class action into an opt-in class action, just by nature of it. Anytime you're telling people, and if you don't want to be part of this class action, you have to opt out, that's flipping Rule 23 on its head. So that would be my argument.
Yes.
The same fact pattern had occurred for class certification, and they moved to compel arbitration. Would Rule 23 have applied in the same way to reach the same result? Would you have denied arbitration under unconscionability?
So the question is whether if the same fact pattern had occurred a little early before class certification was briefed, and if they had moved to compel before class certification was briefed, would Rule 23D still apply? I think so, because Rule 23D allows the court to police pre-certification, so putative communications with the putative class regarding it being misleading. And the fact pattern you often see is not necessarily arbitration agreements, but releases in smaller class actions, or we see them a lot in FLSA collective actions, opt-in actions, where the employer will then try to pick off particular defendants with releases and maybe small payments. These are all pre-certification, but the courts, and I did another case, Johnson versus Serenity, where the employer, it was not a huge class, the employer had a staff meeting and essentially threatened the employees, if you don't sign the release that I'm offering here, you'll be fired. Okay, so, I invalidated the releases that they filed. That was all pre-cert, and that's just policing the fairness of the process.
I will add one thing. I think they couldn't have moved to compel arbitration as to the absent class members part. So my theory, if I would have been defending Avery here, is I would have said I would have introduced it in class certification and said, it creates a predominance issue, and that, the client didn't have standing to challenge the enforceability of the arbitration agreements since he was a former employer or former employee. So I think that would have been, I think, a thornier issue. I think the Ninth Circuit, I think puts that, probably potentially on different grounds, but it's the argument definitely that I would have made, and I think has, pretty good legs also still in the Ninth Circuit, but there's gonna be some tension.
Yeah, no, it's an excellent point, right? Because the Ninth Circuit has said that you can deny, in fact, should deny class certification of a representative plaintiff who is not subject to an arbitration agreement, is not typical of absent class members who are subject to the arbitration agreement, and therefore you can deny certification on typicality grounds. So if they could have done that if they had ruled it out earlier before the class certification.
Although I think the Ninth Circuit said that in the context of the arbitration agreements being added prior to the case being filed. So the assumption being that those arbitration agreements are actually valid with respect to some portion of the class. I think it still raises the same issue. I've actually had some good orders on this that was out of state court, but we did have this issue, and the court essentially issued the same order that you did in the class cert order and said these arbitration agreements are not valid for these class members that you tried to for the litigation had begun, so it doesn't defeat predominance because they're just not enforceable.
Yeah, I would take a very different position on that, but I think, that's one of the great things about this area of law, that it's really ever changing. Especially from creative plaintiffs' lawyers, finding new arguments. And so we have to be creative as well in terms of understanding, I think, how to get enforceable arbitration agreements if that's what your client wants.
By the way, if someone's looking for like a practice area, go become an expert in motions to compel arbitration. You will have, there's so much work out there. There's so much work out there. One issue, when we were talking about this and I was thinking about it, One thing that they didn't raise, and I wonder, is standing, we all know, has become a huge issue in class actions. And did the named plaintiffs in Avery, who were not, they were former employees, so not subject to that arbitration agreement, did they have standing to raise the issue, the Rule 23D issue at all? I mean, they didn't address it. My thinking was that Rule 23D is not like a claim that belongs to somebody. It's a rule, frankly, that belongs to the federal justice system. And it's just sort of empowering judges to make sure the process is fair. And so I don't think that would be an issue, but I don't know. I was wondering about that.
It's definitely interesting.
There's
Yes.
action.
Supreme Court of the United States recently declined to review Georgia decision, SunTrust versus Bickerstaff, did a class rep by filing a lawsuit effectively opts the class out. You familiar with that? Do you have any thoughts?
So the question was, if the Supreme Court denied cert recently on a case maybe out of Georgia that rejected the argument that a plaintiff by filing a class action, no, it accepted the argument?
Opt out on behalf of the class.
To opt out on behalf of the class. A non-certified class? Don't know. I don't, I'm not aware of it.
Case, I've seen that tried by plaintiffs' lawyers, and in fact, sometimes we plead it. We plead an opt-out, especially if you happen to be in the opt-out period. So the only instance is kind of rare when you've had it, and when a defendant is adding arbitration and you're in the middle of the 60-day notice period and you have this case that you've been investigating and you want to, and you hear about this new arbitration provision and you think, oh shoot, I better run to the courthouse right now, and you get it on file and you put in the complaint, I'm opting out the rest of the class. But I've never had to actually litigate whether that litigation holds. So I'm heartened to hear that maybe it would.
So we've been talking a lot of pre-certification, but post-certification, of course, we know that the plaintiff's counsel represents the class, no longer putative class, now the class members. So Sarah, what's a defendant to do? Trying to get decertification or post-summary judgment?
Yeah, I mean, I think in those circumstances, if you're gonna have to go back and revisit some of the evidence that you submitted, whether they were declarations by now actually class members as opposed to putative class members, you're gonna need to run those communications by opposing counsel, or else you're gonna be in hot water. I think is really the only answer with the ethical rules. I think you're probably going to be exploring different forms of proof and different ways to probably attack class certification is my guess, but.
Have you seen opposing counsel do that, Sophia?
Not post-certification. I don't think so. I think you have to be pretty bold to try anything post-certification like that. I think the area that this slide raises is in the context of surveys, and that's another area where this communicating with absent class members can get dicey. And there's a question of when you're trying to survey absent class members on either side, on the plaintiff side or the defense side, and to use that in potentially opposing class certification or in support of your motion for summary judgment. Are you able to do that fairly? And is there a way that you can inform some class members that this is a pending case and that I'm taking this survey for the purpose of potentially filing a motion for summary judgment or opposing class certification that is not misleading? And I think it's a little bit of an open question and an area that we've certainly thought about with defense counsel before.
I mean, yeah, that is one of the things. So in these consumer class action, the false advertising, we often have surveys, right, of whether, but those surveys are almost by of absent class members or even class members.
They're the general public.
Sometimes, I guess you want to make sure it's the general public.
Because when you're talking to class members, just class members, and you're potentially using the results of that survey to undermine their rights, I think that is a little bit problematic or potentially misleading if you're not disclosing that that's the purpose.
One thing I wonder, being given really, as Sarah, you pointed out, pretty much the hard stop on communicating with certified class members, is whether defendants shouldn't think about maybe doing more pre-certification, like a summary judgment or something, motion, because they don't have that same restriction.
I mean, in my practice, we're always evaluating kind of individual summary judgment motions, because sometimes that can be more cost effective, especially if we think, you know, their named plaintiff has problems, and even if they're indicative of a larger class, if you get that on the named plaintiff basis, then, you know, be binding on absent class members. I think it's pretty persuasive as to someone trying to take the next case.
On from arbitration, sometimes a class is pending, but there might be a reduction in force in which you're offering severance to whole classes, no pun intended, whole categories of employees. Does an employer have to exclude from those severance agreements or that reduction in force class members? Sophia or Sarah?
I think, you know, the answer is they don't have to exclude it. And I think, you know, I think it's challenging in these circumstances, especially in a reduction in force where you're going to have, I think, high feelings, certainly a lot of times from employees. And so it's a process where you're going to want, when you're doing a reduction in force, figure out if there's pending litigation. And then I think you're going to have decisions to make if you want it to apply. The release, you generally get a pretty broad release in exchange for severance. Then there's been some expansion, I think, in California, especially as to what you need to include to make that enforceable as to pending litigation, which could include including plaintiff's counsel's name and phone number and disclosure of where the case is at. So I think in terms of evaluating that, I think a lot of people are choosing to exclude pending litigation as opposed to sometimes handing upset people right to plaintiff's counsel.
One of the cases we highlighted there I thought was interesting because I had never seen a defendant try this before, and I really hope my defendants don't start trying this, is this Tolmasoff versus General Motors case. And in that case, it looked like there was a pending class action against GM regarding a defect in one of their vehicles. And what GM did after it had been filed was create a website, and it directed putative class members to that website. It was very neutral. It was nothing like Avery. It explained the facts of the case. It explained the defect. It cited plaintiff's lawyers and gave contact information. But it also said in a very easy, clickable way that, you know, if you would just like to expedite this process and sign a release with us, here's $200 and here's your release. You can sign this and exclude yourself from this pending class action. And the court upheld it. The court said that that was fine because it wasn't misleading and people were allowed to enter into voluntary settlements with defendants if that's what they chose to do. So I think what that case would say would be there's probably a way that defense counsel can communicate with absent class members and secure releases in a non-misleading manner, but you do have to be very, very careful about how you do it.
We had a cite to Lopez up there that has some interesting, interesting kind of distinguishing between what they will uphold and what they won't uphold for RIF releases. Those concerns. I think we're getting close to time, but oh, look, we're in. Great.
Yeah.
So any other questions? Yes.
One more.
Yes.
I did a quick skip of the name. It looks like it was upheld on federal rule 23 grounds solely. Do you think, or was there an unconscionability argument as well that the class action waiver was just unconscionable because of the way it was rolled out, and that could have been a way to invalidate it?
I don't remember, I had an alternative ground, which was waiver, that they had waited too long, in part waiting 22 months into the litigation to even roll it out. I don't recall that, we didn't even need to get there. Yeah. Great, so yes.
That's what I was thinking. Can't sit back and wait and see what happens. And motion to set and discover and say, now have arbitration.
It comes up all the time. I'll tell you what I do to try to avoid that is when I get the initial case management conference statement and a defendant start making noise about a motion to compel arbitration, I give the defendant a deadline. So I don't let them wait. And it's either decide one way or another. I give them a deadline. So I try to, cut that off. But waiver definitely comes up. Great. All right. Thank you.